We're actually live. Okay. All right. Good morning, everyone. This is some natural resources and energy, and it is March 14th, Pi Day, I might observe. And we are joined this morning by Rich Ressman from the Transportation Committee. Yeah, so welcome.
Thank you for having me.
Yeah.
Should I just start talking?
Yes, go right ahead.
So Rich Westman, Chair of the Senate Transportation Committee. I will apologize. We've been sharing the drafts person that you have, and I think you have Mr. O'Grady quite busy, and we don't have a copy of the draft, but from a high level, I'll tell you what we did in that draft and what our intentions were. Our only concern in the bill that we felt related to us directly was the issue of salt and sand sheds being covered. We had the Agency of Natural Resources into our committee. They had pretty specific numbers around the Champlain watershed, and that the numbers they gave us were that roughly 2/3 of all of the salt and sand piles were covered within the Champlain watershed. They really didn't indicate to us what the numbers were in the rest of the state. And our experience has been that it has been very difficult for small and medium-sized communities to financially afford the covering of salt and sand sheds. So what our amendment did, and A&R agreed with this, and we had drafted is in first year instructing them to in the funding sources to make covering salt and sand sheds a priority, and coming back in a year to us and giving us the full picture of what's covered and what's not around the whole state, with a report back to us about that, and a recommendation on what they feel each year the appropriation should be to accomplish that in the timeframes that have been laid out in this. Our worry is, and I will give you the backdrop of where we are. We've been presented, if you're going to do a specific project in transportation, you're probably going to go to class 2 roadway or structures, and doesn't deal specifically with salt and sand sheds. But in this budget that's been proposed to us for this year, there's $1 million cut in those programs. Almost every program that deals with money for towns is either flat or cut. And part of that relies in the anemic nature of the transportation fund. And that the money, most of the money that we send to towns is all state dollars. Unless it's a bridge over 20 feet long in a community, any help that we give them as a state is total state dollars, and we're starved for state dollars. And the outlook for us is bleak. So given that is the fact, when we're putting what will be a mandate on particularly small and middle-sized communities without a lot of resources and less help from us in other areas, we felt quite strongly that in the priority list going forward, that we need to give small and medium-sized towns a place to go. Okay.
Yeah, fair enough.
And because this will not come to our committee, And we've had many conversations with your chair, Senator Watson. The amendment from this will be offered by the 5 members of the Transportation Committee.
Okay,
Okay,
thank you.
Great.
Thank you.
Super.
can I go now? Can I go now?
Any questions for Senator Westman?
Thank you.
Okay, super. Thank you. All right. And that's we didn't take a straw poll just now, but at least from my perspective, that all sounds fine. Anyone else want to offer any thoughts on that?
Sounds good.
Yeah. Good. Okay. So would it be fair to say that we have no objections to that?
Got it. Yeah. No objection.
Okay. Amazing. Great. So I believe next on our agenda is I think it's Scott Sanderson. And Jude, I'm gonna look to you to see whether or not he is either in the Zoom or in person.
Yeah, he's here.
Okay. We'll
On
just jump
Zoom.
on Zoom. We'll just jump right into it. So switching gears to a bill that we have not yet really started, S100. And I want to recognize that the order is a little funny here, but we're just trying to accommodate the agenda of our, or I guess I should say the calendar of our Ledge Council folks. So so anyway, this is the order that we landed with, and we're gonna roll with it. So welcome, Mr. Sanderson.
Good morning. I'm going to try to share my screen here so that I've got a couple of slides to share. Let's see if I can figure that out. It's always the first challenge. Let's see. Okay, are you seeing slides?
Yep.
Fantastic. Okay. Well, good morning, Chair Watson, members of the committee. My name is Scott Sanderson. I'm an attorney and the director of Conservation Law Foundation's Farm and Food Program. I also manage the Legal Food Hub, which is a free service that connects income-eligible farmers with pro bono legal assistance. And thank you so much for inviting me to discuss S100 today. Before I address the bill directly, I'd like to put the bill into a little bit of context. So my understanding is that S100 is a response to EPA's recent finding that farm regulation in Vermont does not meet the Clean Water Act's minimum requirements. I think it's important to understand why EPA arrived at its conclusion because it makes it possible to evaluate S100 and its alternatives. I also think it helps show why S100 doesn't resolve the problems with agricultural water quality that EPA identified. So to do that, I'm going to discuss delegation and de-delegation of authority under the Clean Water Act, since that's the process that Vermont is in right now, how agricultural water quality is regulated in Vermont right now, the de-delegation process that is ongoing in Vermont, and then I'm going to shift to S100 and contrast it with H146, which is an alternative bill that the House is considering right now. And after that, I'll conclude with a couple of thoughts on how the bills move forward. Okay, so starting with delegation and de-delegation under the Clean Water Act. So what is delegation or program approval? Basically, under the Clean Water Act, EPA is authorized to delegate its authority to state programs, basically allowing states to run the Clean Water Act within the state in EPA's place. But when EPA does that, states operate under various requirements, and their state program has to always meet the minimum requirements of the Clean Water Act. If any part of the program doesn't meet the minimum requirements of the Clean Water Act, EPA can respond to that. And so when EPA
Chair, can I interrupt for a minute? I got a question. I see the EPA symbol. I'm not familiar with Conservation Law Foundation. Are you an arm of the EPA?
No. We're not. We're a regional environmental nonprofit that works out of Montpelier, and we have offices in all 6 New England states.
Okay. All right, thank you.
Absolutely. And so when EPA delegates authority to a state, it doesn't step out of the state entirely. It moves into an oversight role, and its job then becomes to make sure that state programs comply with EPA with the Clean Water Act's requirements. Now, in that role, if EPA then finds that a delegated program no longer complies with the Clean Water Act, EPA is authorized to take back its authority. And it can do this for a number of different reasons. It may be that the state is failing to issue required permits. There may be conflicts between state regulation and federal regulations. The state may fail to inspect or monitor regulated entities like farms or wastewater treatment plants. Or the state may fail to enforce violations of the Clean Water Act. Now, when EPA finds violations like this, they don't simply, de-delegate with a snap of their fingers. They go through a process, and that process can take quite a lot of time. And they want to make sure that the state has an opportunity to correct any deficiencies in their program. EPA's, to my knowledge, never de-delegated the NIPD's program of the Clean Water Act from a state. So this is how the process usually works. Basically, it usually starts with EPA receiving a petition from a petition that alleges that a state is violating, that a state's program doesn't meet the requirements of the Clean Water Act. EPA will review that petition, and if it thinks that there's merit to it, they'll conduct an investigation and make findings. They will then require the state to correct any deficiencies that they found, and that may require legislation on the state's part. And I just want to emphasize that this can take time, right? EPA recognizes that states have to tailor their programs to meet their state's needs, and it can take time to figure out how to do that, especially how to reorient programs that may not be working as well as they should be under the Clean Water Act. So EPA doesn't look for an instant solution. They look for states to make diligent progress. And once the issues are resolved, EPA will usually dismiss the petition. So that's generally how they handle this sort of thing. Okay, so the next question then is, how is agricultural water quality regulated in Vermont right now? There are two delegations of authority that underlie how Vermont regulates agricultural water quality. The first is that in 1974, EPA delegated authority under the Clean Water Act to ANR. Then in 1991, the legislature required ANR to delegate authority to regulate agricultural non-point source pollution to AAFM. And so that has led to a program that is characterized by divided authority between two agencies, ANR and AAFM. And the key division here is authority over point source pollution and non-point source pollution. The best way to think about a point source is a pipe, right? It's a very discrete thing that you can point at that pollution may be discharged from. However, in an agricultural context, what is a point source and what is a non-point source can be very complicated. For example, runoff from a field can be non-point source pollution or point source pollution, depending on whether or not a farm is implementing something called a nutrient management plan. So this slide outlines the divided responsibilities between ANR and AFM right now. ANR is responsible for point source pollution. They're responsible for issuing NIPD's permits, which are Clean Water Act permits, to CAFOs, which are concentrated animal feeding operations, which are a class of farms that the Clean Water Act regulates differently because they present a particular risk to water quality. And just to note that every large farm operation in Vermont is a concentrated animal feeding operation also under the Clean Water Act. By contrast, AFM, they deal with non-point source pollution. They run the state LFO, MFO, and CSFO programs, large farm operation, medium farm operation, certified small farm operation programs, and they administer the required agricultural practices. So this division means combines with ANR's responsibility to control point source pollution to make Vermont's program very dependent on collaboration between ANR and AAFM. And so there's a big challenge here. AAFM conducts most inspections on farms, but ANR has to control point source pollution. And so how do you manage that? And the solution that Vermont has tried for a very long time is to require collaboration between the two agencies through a memorandum of understanding. This is actually the third one that the state has had to try to arrange the relationship between these two agencies. And what the MOU provides is that it recognizes that AAFM is generally going to be the inspector. And it essentially says that if AAFM sees anything on a farm that looks like it may be a point source discharge, it is supposed to promptly document that and refer it to ANR so that ANR can conduct an investigation and determine whether or not there's a Clean Water Act violation. That's how it is supposed to work in theory. What EPA found is that that generally doesn't work in practice. And so that takes us to the ongoing dedelegation process in Vermont. And I just want to highlight that this is a process that has a very long history, so long that I couldn't quite get it onto one slide here. It started back in 2008 when Vermont Law School's clinic, along with Conservation Law Foundation, I believe, filed a dedelegation petition that dealt with essentially all of Vermont's Clean Water Act program. But I just want to highlight that one part of that petition dealt with farm regulation as well, and EPA did require Vermont to begin fixing how it regulated farms. And in particular, it found that ANR had never issued a Clean Water Act permit to any CAFO in Vermont, right? So basically it wasn't regulating farms as the Clean Water Act requires. So this is a very long-standing, there's a long history of this in Vermont. Now, Vermont reacted to EPA's findings by passing legislation that reformed quite a few things. However, unfortunately, agricultural water quality remained a significant problem. And so in 2022, Conservation Law Foundation, Vermont Natural Resources Council, and Lake Champlain Committee filed a second dedelegation petition that focused specifically on the agricultural water quality program in Vermont. It led to an EPA investigation. It was a 2-year investigation that involved EPA reviewing records, speaking with ANR, conducting their own independent investigations of farms, all those sorts of things. And they made conclusions or issued conclusions in September of 2024. And that brings us to the slide that I started this with. EPA's main conclusion in its letter, which I've thumbnailed here, is that ANR's program operations are clearly failing to meet the requirements of the Clean Water Act. And they cited 4 primary reasons justifying this conclusion. The first is that they found inadequate monitoring and enforcement on farms. And so here's the quote: "In general, ANR fails to conduct sufficient and timely inspections and fails to take appropriate enforcement actions to deter or mitigate violations. And this is because ANR largely relies on AAFM to be their eyes and ears on the ground." Basically, the collaboration between ANR and AAFM isn't working, and that makes it impossible for ANR to control the discharges that it is required to under the Clean Water Act. They also found problems with state regulations, basically conflicts with federal regulation. They found that ANR was not requiring Clean Water Act permits on CAFOs that were actively discharging. And they found that there were problems with manure management. So essentially that farms were not implementing nutrient management practices, or nutrient management plans, and were consequently applying manure at inappropriate application rates and in fields that were unsuitable, resulting in water quality problems. So EPA found these 4 issues, and they traced it back to 2 primary causes. So the first cause was the division of Vermont's agricultural water quality program between ANR and AAFM. And then the second was insufficient resources allocated to ANR to administer the CAFO permitting and enforcement program. And based on those causes, they outlined 2 practical solutions. The first being consolidated agricultural water quality authority in ANR. So basically create a unified program. And the second was to adequately resource ANR. So that all happened back in September. In December, ANR responded with a draft corrective action plan, basically saying, here's what we'd like to do to resolve this petition. And EPA reviewed it and decided not to approve that plan. And they basically found three overarching problems. The first problem was that the draft plan didn't adequately consolidate authority in ANR. It relied too heavily on AAFM. And you can see the quote on the left here that EPA is reminding the state that in the history of NIFTY's regulation in Vermont, the divide between ANR and AAFM has led to confusion in regulatory inaction. The second problem was that they felt that the plan was not the plan didn't adequately resource ANR. Basically, they questioned whether or not the staffing requests or the staffing ideas in the plan were sufficient. And then they were worried about missing details around things like permitting requirements and milestones. So when ANR was going to achieve certain things and what they were going to achieve. But then I'd say that, true to EPA's form and how they've handled this kind of a process in other states, they required diligent and steady progress, but not haste. So they said, okay, this plan doesn't quite meet our specifications. And they directed ANR to submit a revised plan to EPA on March 18th, which I believe is Tuesday, or is next Tuesday. They also said, you may not have a complete plan yet, but ANR should begin work that it is already authorized to do. For example, they pointed at that ANR should begin hiring to bolster its CAFO program where possible, and to begin conducting more inspections. And then they also highlighted that progress on legislation was important, but the way that they framed this was that they wanted to be kept apprised of draft legislation, changes in the legislative landscape, things like that. And they said that because they think that resolving this issue is going to require legislative intervention, and that the petition ultimately won't resolve without legislative intervention. Now, I just want to emphasize on this that I don't interpret EPA's letters as requiring a sort of a must-pass bill this year or anything like that. I think EPA recognizes that these things take a long time. That is true to their history and how they've handled this in other places, and even in Vermont with the previous dedelegation petition. So steady progress seems to be the key. Okay, so this is where we are now, right? EPA has required ANR to revise its draft plan by March 18th, and the legislature has an important role to play. And so there are a number of bills that are being considered. And so, of course, there's S100 in this committee. There's the miscellaneous ag bill, which essentially has S100 in it. And I believe the Senate Agriculture Committee considered that yesterday. And then in the House, there's H146, which takes a very different approach from S100. And so now I'm going to shift towards S100 and contrast it with H146. I understand that S100 is being presented as a sort of a provisional step, and that perhaps there would be future legislation. It's a way to get started. However, I think it's still worthwhile to evaluate S100 against EPA's criteria, the problems they'd like to see solved, because S100 is quite a comprehensive bill. And so I think it's important to go through how it doesn't quite meet EPA's requirements. So this is the list of EPA's requirements that I've pulled from their letters. And basically, these are the challenges or the deficiencies that a bill would have to address. So it would have to address split authority, which is undermining regulation, inadequate monitoring and enforcement, failure to require Clean Water Act permits on CAFOs, failure to require proper manure management, problems with state regulation, and insufficient staffing and resources at AAFM. So those are the EPA problems that they found. But I would also highlight that I think it's important to think about proposals to resolve these issues and to evaluate them in terms of the degree of clarity, consistency, and predictability that they provide to farmers, right? I think it's really important that farmers be interacting with a system where they know what they need to be doing, they know who they need to be interacting with, and that it not be confusing or cumbersome. So I would have that in mind as well. So of course, you're going to be getting a walkthrough, I think, of S100 from Legislative Council after I chat, but this is my understanding of what S100 does. And so mostly my understanding is that it maintains the status quo, including split jurisdiction between ANR and AAFM. And this doesn't align with EPA's findings and their directions. Second, it requires a new MOU governing ANR and AFM's relationship. It doesn't call the document an MOU, it calls it a document, but it's a very similar idea. And I've noted that there have already been 3 of these MOUs that have so far not succeeded in coordinating the agencies to create a program that meets the Clean Water Act's requirements. Third, it continues to use both state permits. Yes. Oh, sorry. Oh, should I keep going?
Yes.
Okay. Third, it uses both state permits and Clean Water Act and NIFTY's permits, but it doesn't establish, in my opinion, clear-cut permitting criteria. And so I think the risk here is that farmers will basically get ping-ponged between permitting systems in a way that is a little bit unpredictable and could risk being inconsistent across farms. So farms will be going between 2 permitting systems and 2 agencies. I think that's a little bit tricky. Third, the bill creates a stakeholder engagement process, which is a positive step. But I think that process needs to be adjusted to align with EPA's regulatory expectations. And what I mean by this is that I think the way that the stakeholder process is framed could create the unrealistic expectation or the unrealistic perception that maintaining the status quo is a possibility. And then fifth, the bill provides ANR a couple of important powers that I don't think ANR has right now, including the power to access AFOs. AFOs is yet another category of farm in the Clean Water Act. Essentially, all dairy farms in Vermont are AFOs. And so it gives them access so that they can conduct inspections, and it also authorizes them to hire contract inspectors. So now pairing this bill up on that list of deficiencies that need to be corrected, I think the first one, split authority, I don't think that the bill addresses that, right? It essentially maintains the current jurisdictional division between ANR and AAFM. Fundamentally, we keep splitting things between point source and non-point source regulation. And so farms will have to go back and forth between agencies depending on what's going on. And then I think second, it continues to depend on this MOU idea to resolve long-standing problems with collaboration. And I think, the MOU hasn't worked, or several iterations haven't worked. I think it's unlikely to work going forward. I think it's an open question whether S100 deals with monitoring and enforcement is going to address, will resolve this. And that's because it doesn't require ANR to inspect all farms or to conduct regular farm inspections. It basically leaves this to the agency. And without broader restructuring, I think the result is that may force ANR to continue to rely on referrals from AAFM, much like the current system, which isn't working, which EPA found flaws in. I think it's a similar story with whether the bill gets us to requiring NIFTY's permits on CAFOs when they're required. The permitting criteria are not clear cut to me in this bill. And I think that is a potential weakness. I think that the bill doesn't address nutrient management planning and manure management. And that's primarily because the bill doesn't make ANR responsible for enforcing nutrient management planning requirements. It mainly focuses on making nutrient management plans available to ANR when ANR conducts a farm inspection. And with that in mind, I mentioned earlier that the difference between a point source discharge and a non-point source discharge on a farm often hinges on whether or not a farm is implementing a nutrient management plan appropriately. I think that what this structure does is it basically forces ANR to rely on AAFM's enforcement of the required agricultural practices. There are some problems with state regulations as well. For example, there is a presumption that farms do not discharge if they are deemed in compliance with the RAPs by AAFM. So that puts AAFM inside a core Clean Water Act regulatory decision. There's also the large CAFO definition in this bill is also less stringent than the Clean Water Act definition, which is a bit of a problem. And then I think it's an open question about staffing. That's not necessarily a problem with S100. It's just something that is going to have to be considered as this all goes forward. So the contrasting approach is right now that is in the legislature is H146. And what H146 does, it takes a very different approach. It consolidates authority to regulate agricultural water quality in ANR, including the RAPs and the LFO rules. It requires ANR to conduct inspections at regular intervals on all jurisdictional farms. It shifts from mandatory LFO and MFO permits, so those are state permits, to mandatory Clean Water Act permits. So it basically shifts permitting systems in order to ensure that farms know what permit they need to be on and keep them in a single permit system rather than a multi-permit system. One thing that it doesn't do, I think that's important, is that it doesn't take away AAFM's role in providing technical assistance, grants, and support to farmers. It keeps AAFM in that role. And then it also establishes a 3.5-year transition between the two systems. And one thing that I'll just point out about 146 is that it is structured in a way that disrupts farmers' experience of the regulatory system as little as possible, right? So a lot of things are consolidated into ANR, but fundamentally the main difference that a farmer experiences is who is going to be regulating, not the number of regulatory programs they're going to be encountering. So they'll be encountering inspections on the normal cadence that they usually do, but it would be ANR who's doing that. They'll need a permit, but they'll just need one permit, much like they do now, and it'll be a Clean Water Act permit. They'll still be regulated under the RAPs, the LFO rules, the MFO rules, but ANR will administer, not AAFM, sort of on down the line, keeping this experience as similar as possible. And if we go through our checklist, I think H146 comes closer to EPA's requirements, right? It's going to consolidate authority, which deals with split regulation. It's requiring ANR to inspect all farms at regular intervals, with larger farms being inspected more frequently. So that should address the monitoring part. With NIPD's permits, what it does is instead of applying a lot of discretionary criteria, or we have fairly discretionary criteria to determine permitting requirements, it simply requires permits, much like the current system does with large farm operation permits, right? So farms will need a permit. They will need a Clean Water Act permit, and that permit will meet Clean Water Act requirements. It will also be issued by a process that creates more public transparency than the current system. And it will also give farmers protection from liability that the current permitting system doesn't give them right now. It does a little bit better on the manure management, right? So it requires CAFOs and AFOs to implement nutrient management plans that meet USDA standards. It resolves some problems with state regulation. And though I will note, much like S100, while it does shift the Agricultural Water Quality Special Fund, it's going to need some attention as to how to deal with staffing and resources. So as between the two bills, I think that H146 probably comes closer to addressing EPA's concerns than S100 does, which I think certainly doesn't address EPA's concerns. And just a couple of thoughts on process. I think that S100 would benefit from a significant discussion, and H146, I think the same, right? EPA's letters in practice, it requires states that are going through this dedelegation process to make diligent progress, but it doesn't require states to go super fast or to be hasty, right? I don't think that the legislature is under pressure to get something out by crossover or to get a bill out this year. I think the end of the session would certainly satisfy EPA. I should say the end of the biennium would certainly satisfy EPA. And I also just want to highlight that I think S100 and H146, both these bills weigh really complicated decisions that require a lot of time, discussion, and input to resolve, right? So I think input is a particularly important thing to flag. I think it's important that folks from the farm community and folks representing the farm community have opportunities to testify on these issues, whether it's Farm Bureau, Champlain Valley Farmers Coalition, right? These are super important issues, and I think that it will take quite a lot of work to find a solution that works well for everyone involved. And I just highlighted a couple of issues here, right? We talked a little bit about when to require NPDES permits as an issue that has to be gone through, but also there are other things like how to define waters, which is a very important jurisdictional decision that S100 makes. It uses a less stringent definition than is currently in Vermont law. Similarly, there are things to worry about with how do you align Vermont's agricultural water quality and non-water quality programs. For example, right now, the LFO rules combine some non-water quality stuff with some water quality stuff. So how do you disentangle those things? And then also, of course, how do you transition between the status quo and a program that meets all the requirements, right? It's probably difficult to change things overnight, but getting a process right, getting that transition right will be important. And then I think one last important question to consider is what does ANR need to get started? So, again, I realize that S100 is, or at least based on testimony in Ag and Senate Ag yesterday, is being presented as a sort of a stopgap measure. And I think that it's important to sort of figure out what powers ANR does not have right now that it needs to make progress on year one, maybe year two of its corrective action plan. I don't think that there are many powers in S1 or many powers that ANR is missing in order to start making progress. But but if there are powers that are missing, it could be helpful for ANR to have those. And so in any case, that's what I have for you. So I'm happy to take questions, and I'll see if I can't stop sharing here.
Great. Thank you. Any questions for Mr. Sanderson at this point? Okay.
No questions, but that was informative. Thank you.
Thanks.
Yeah, thank you so much.
Absolutely.
All right, so I would like to take a little break before we Michael will be next. Yes, before we have Mr. McGrady with us. I'd like to meet back like 5 minutes or just a few minutes before 10. Is that okay? Can we do that?
Yeah.
That'd be great. Thank you. Okay, we are back, this is Senate Natural Resources and Energy. First of all, before we get started, I need to apologize, Senator Hardy, I'm so sorry. We did this in a wonky order, I would say the wrong order. And I recognize that we started with a lobbyist, appreciate what he had to say. But we should have started with Senator Hardy, and who is the lead sponsor of this bill. And so I wanted to just take a moment to reset our brains, to sort of take what we heard and set it aside. And before Mr. O'Grady walks through S100, and if you would like to, if you would like to just tell us about S100.
Thank you, Madam Chair. Well, as we got some testimony last week, I believe, about this issue, and as I mentioned, there would be maybe it was 2 weeks ago, time is weird now, but I mentioned there would be a bill coming, this is the bill, and I appreciated what Mr. Sanderson said, and all the work that his organization has done, but really, this bill is I introduced it in large part at the request of ANR to get something moving so that we can start addressing this issue so that they can get the authority they need and the transfer of sort of what needs to happen starts to happen. And that there can be a stakeholder process that is established so farmers can really be in the conversation as a transition is happening. And a lot of the things that Mr. Sanderson noted are actually to be discussed by the stakeholder group. So it's really important that farmers are able to have their voices heard, and not just in this building where it may be more uncomfortable for them to talk about it, but really in a process with other farmers and the agencies and their peers involved. And there also is in the budget, in the governor's budget, there are positions and funding to make this happen. So the concern about the resources is traveling in a different document in the budget bill. And my understanding, and Michael will talk much more about this and knows much more about this than, but that this language is basically the basic requirement of what the EPA is ordering. And I think some of the urgency is one, to get things moving and giving ANR the ability to do what the EPA is asking, but also some of it is the sort of uncertainty at the federal level and wanting to make sure that we are moving along with the process. It sounded like the bill was not going to move in the House, and so having a vehicle that is moving before crossover is really helpful. I know the Ag Committee has done, I think, put this in miscellaneous ag bill. I didn't know that was gonna happen, but that's where it is happening right now, so. But I'm not gonna talk about the details because Michael knows that way better than me, so.
Okay, thank you, yeah. Go ahead.
So this is Mike O'Grady with Legislative Council, just working off the S100 to, just reframe the context of Senator Hardy just did a great job of summarizing EPA in their corrective action request outlined certain things that needed to be done. And those included statutory changes to clarify the authority of the Agency of Natural Resources over the permitting of CAPOs in the state, to maintain the state's delegated Clean Water Act authority to issue those NIPD's permits, SIPD's permits in Vermont. This is what the agency, the administration as a whole is offering to address that part of the EPA corrective action request. And I don't know if I would characterize it at the minimum, but it is what they would propose to satisfy EPA. And so and to address the last point that Senator Hardy made about how the Committee on Agriculture has added this to their miscellaneous ag bill. They did so because the Agency of Agriculture has changes that they would like to see to their authority that is not in S100. So basically to combine those two proposed changes, this bill and what the Senate and what the Agency of Ag has requested, likely needs to be done at some time. Whether it's you do it in this bill or if you do it in the Miss Ag bill, you'd likely to do that at some point. So going forward, just stepping through the bill, section 1 is amending the definition section in chapter 47 of title 10. That is the definitions for water resources, the statutory requirements for water resources. Page 2, and then the definition of discharge, the term pollutants is being added. Vermont requires a discharge for waste. Federal Clean Water Act requires a discharge for pollutants. In order to be fully consistent with the Clean Water Act requirements for CAPO permitting, pollutants needs to be added to the definition of discharge. Going down on page 2, I want to note lines 12 through 15. The state definition of waters is very broad. It's pretty much everything you can think of: rivers, streams, creeks, brooks, reservoirs, ponds, lakes, springs, and all artificial and natural bodies of surface waters in the state. We're going to get to why that's an issue in a second. Page 2, there's a definition of continuous discharge. When I was reviewing the bill last night, I realized that you might not need this definition. It's not used in the bill, and I wanted to talk to the agency about, is it being added for other parts of the program or not? But so just to flag that may potentially come out. There's a definition of daily discharge. It's based on the federal Clean Water Act permitting definitions of daily discharge. It's the discharge of a pollutant measured during the calendar day or any 24-hour period that reasonably represents a calendar day for purposes of sampling. It's something that's required to be reviewed, or as a standard, I should say, underneath the Federal Clean Water Act rules. So it's being added as a definition here. As I discussed when we first started, the definition of pollutant was added to the definition of waste or discharge, I should say, because that is the standard under the Federal Clean Water Act. I'm going to stop here. Remember, we were talking about the definition of waters. You will see in the Senate Ag bill that comes over, there's a definition that's missing here, and that is a definition of waters of the United States. The Federal Clean Water Act, its permitting authority relates to the waters of the United States, and it is not as broad as the definition of waters in this bill. You're probably going to have a discussion about which definition you want for purposes of the Agency of Natural Resources jurisdiction over CAFOs, because think if you're the agency's definition, the agency's jurisdiction is going to apply to discharges to broad definition of waters, or is the agency's jurisdiction going to apply to a less broad definition of waters of the United States? And that's a policy decision for purposes of this bill. Moving on into section 2, you're adding a new subchapter on concentrated animal feeding operations. It has its own definitions. At first, there's a definition of agricultural waste. It's based on a definition that's in the Agency of Agriculture statutes today. It's just being moved over for purposes of regulation by ANR. Then you get to a very key term, page 4, line 3 through 17. What is an animal feeding operation? Because in order for ANR to regulate a discharge from a farm, the farm has to be an animal feeding operation. And an AFO is a lot or facility where the following conditions are met. There are animals that have been or will be stable, confined to fed, or maintained for a total of 45 days or more in any 12-month period. And the area does not sustain vegetation, forage growth, it's denuded during the normal growing season. So 45 days or more in any one facility, place, etc., and there's no vegetation there, that is an APO. And if there's a discharge from that, that's where A&R will have its authority. When you have two or more of them that are adjacent to each other, the agency's authorized and actually required under the Clean Water Act to treat them as one. So you can't divvy up your farm to try to circumvent the number requirement. They're gonna just treat you all as one.
Question right here.
What if it's a stable, like you got a arena inside a contained building and you feed animals in there?
So you're gonna see later on, a definition of protection facility which is basically where the APO is gonna be found to be. And it's gonna include where animals are held, maintained, trained. So moving down on page 4, line 18 or 19, there's a definition of concentrated animal feeding operations. That means an APO that's either large, medium, or small. And that brings us to what is a large concentrated animal feeding operation on page 5. This is kind of the reverse NOAA SARC list. It's not two of everything, it's how many hundreds or thousands of things are going to qualify you as a large APO. And for purposes of Vermont, dairy animals, it's 700 mature dairy animals or more, and you are a large concentrated animal feeding operation. And you have to meet certain conditions. That there are waste discharged into waters of the United States via a point source. The wastes are discharged directly into the waters that originate outside of the facility, but pass through, across, or through the facility, or otherwise come into direct contact with the animals that are confined in the operation, or a precipitation-related discharge of manure, litter, or processed wastewater from land areas under control of an LFO has occurred that was not in accordance with site-specific nutrient management practices. That's important because under the Federal Clean Water Act, a discharge is from a point source, and a CAPO is a point source, unless it's agricultural stormwater. And agricultural stormwater has been interpreted to mean when you're land applying manure, nutrients, etc., and you're doing it according to site-specific conditions, usually construed to mean a nutrient management plan. If you are doing that and things run off into the water, that is not a discharge. But if you are not complying with your nutrient management plan or site-specific condition, and you're land applying, if it goes into the water, that is a discharge. So that's basically what page 6, line 1 through 5 says. If you're not following your site-specific nutrient management practices, then that is a trigger for the agency to say that you are a large CAPO and you need a CAPO permit from them. I think everybody knows what manure is. You go to medium concentrated animal feeding operation. Again, it's a numbers, it's 200 to 699 dairy cow. And there are only 2 conditions here that would trigger for A&R's permitting authority. It's whether there's an actual discharge from a point source, and whether the discharge originates outside but flows through the facility or comes in contact with water. There's
Yes, question here.
So, sorry to interrupt you, but in this definition and in the previous one, it uses the waters of the United States definition, which is not in the bill, is that what?
which is not in this version of the bill. I don't remember when Catherine and I conferred about that.
Okay.
Whether it was this or another version, there's been a couple of
Okay.
versions.
And this is the narrower definition.
This is
So-
narrower, but there's also a question of whether or not, for administrative purposes, you want to go with the broader definition because that's what the agency already permits for it's other programs, it's other entities.
Right, and I think that's what we just heard in the testimony that CLF was sort of about the definition of waters, so I just wanted to understand that.
Yeah, so it may be more, so either we need to add a definition of waters of the United States, or we need to do it consistent.
Right,
Yeah,
just
okay.
say waters.
Yeah.
So.
Okay.
Page 7, line 10, this is, actually, no, I didn't get to that. Page 7, lines 1 through 6. For a medium farm to require a permit from A&R, they have to have the numbers 200 to 699, and then they have to have the waste or discharge or the waste, our discharge that originate outside the facility and pass through the facility or come into contact with the animals. I want to note that it doesn't have that third concept of not complying with your site-specific nutrient management practices. I still think the agency could assert jurisdiction. There is a little bit of discussion about that, but I want you to like flag that. That's something to come back to.
Wait, I'm sorry.
A&R, agency not the responsible.
Yeah, so here's a way to look at it. On top of page 6, line 1 through 5, one of the ways that a large farm may be required to obtain a CAFO permit is that they're not complying with their site-specific nutrient management practices. That's one of 3 things that can trigger the need for that large farm to get a CAFO permit. But for a medium farm on page 7, you don't see that third option. It doesn't say if you're not complying with your site-specific conditions that might trigger your need to get a medium CAFO. There is some discussion about whether or not the federal law requires that for medium farms. But I don't know if leaving it out here changes the agency's authority to say you're not complying with your nutrient management plan, you have a discharge. And so whether or not to include it here, it's a valid discussion, but I don't know if it changes the agency's authority. So moving on page 7. There's a definition of point source. I love this definition because it's the federal definition, but it equates a pipe, a ditch, a channel, a tunnel, a conduit, a well, etc., with a concentrated feeding operation. So that farm is the same thing as a pipe, unless it does not include agricultural stormwater discharges and return flows from irrigated agriculture. So agricultural stormwater is when you are land applying nutrients, etc., according to site-specific conditions. The definition of processed wastewater it's basically what you use for washing, cleaning, flushing the barn, or when there's direct contact with animals, or for dust control, basically where the water can pick up all the pollution. And then so there's a definition of production area I was referencing in response to the question about stables. It literally says stables. Production area means that part of it, CAFO or CAFO, that includes the animal confinement area, the manure storage area, the raw material storage area, and the waste containment area. It includes open lots, house lots, feed lots, confinement houses, stall barns, milk rooms, milking centers, cow yards, barnyards, animal walkways, and stables. It also includes their lagoons, runoff, ponds, etc., composting piles, raw material storage areas, settling basins. All of those things are within your production area. And they're likely the thing that is going to trigger a determination that you're an AFO, because that's where the animals are held for 45 days or more in a year. And there's usually no vegetation in most of these areas. Moving down on page 8, line 18, there's a small feeding operation, so it's an AFO that's small. That means it's gonna have under 200 mature dairy animals. Small concentrated animal feeding operation, moving on to page 9. Let's just stop here. So the agency has discretion to determine whether a small AFO is going to need that concentrated animal feeding operation permit, and they will look to determine, even if there's a discharge, whether or not to bring it in. And you'll see that later in the bill. But so small AFO can trigger the need for a CAFO permit when waste are discharged into waters via a point source, and waste are discharged directly into waters that originate outside and flow through or come in direct contact. This is where you see the waters of the United States definition as being defined by the federal regs. But it's still the same discussion, it's still the same.
But this one has discharged into waters, and the other two have discharged into waters of the United States.
I do think there needs to be consistency in the use of term. So just for context clarification, what is the water of the United States? Well, we don't know, because the EPA just said they're gonna change it yesterday, again, so like the 4th time in 5 years. And, but as it's defined today, it's navigable waters, intrastate waters, tributaries of navigable waters. And there are a couple of others, but then wetlands with surface connections to tributaries of navigable waters or navigable waters themselves. So that's much narrower than the definition in Vermont of pretty much all waters. Then you come to the powers of the secretary, which is page 9, line 9. The secretary has authority to do basically what she needs to do to implement this program. To administer the VIPT's CAPO program consistent with the Clean Water Act, make it revise and then rule necessary to administer the VIPT's program. Issue guidelines and procedures. Designating AFO that meets the definition of CAPO in the secretary's sole discretion, designating small AFO as a CAPO. If after on-site inspection, the secretary determines that the small AFO is discharging a significant contributor. So that's where the secretary has some discretion to determine an AFO, small AFO needs a CAPO permit or not. And when she does that, she'll look at certain factors, including the size, location, means of conveyance, site conditions, and other relevant factors. She will have access to private property to inspect the AFOs. She can solicit and receive federal funds. She will also, I want to note page 10, line 15 and 18. She will have access to the farm's nutrient management plans. And especially if the farm is determined to be a CAPO, the nutrient management plan is going to be part of the permit and the permit process, which means it will be public. Page 11, she'll fully cooperate with the federal government, other agencies, and she will appoint assistants or contract with persons, perform or assist the requirements of the chapter. Then you come to page 11, line 7, the CAFO requirements, permit requirements, and exemptions. The discharge of manure, litter, or processed wastewater to the waters of the United States from CAFO as a result of the application of that manure, litter, or processed wastewater to land areas under its control is a discharge, except where the manure, litter, or processed wastewater has been applied in accordance with the site-specific nutrient management plan. So it doesn't say just for large farms, that's for any farm where that could be bought, that scenario could require a discharge permit. But then you have an exemption, page 11, 14 through 20. When there's a precipitation related discharge, for land areas under the control of an LFO, it will be exempt. Only where the manure litter or processed wastewater has been land applied according to site specific measurements and other practices that ensure appropriate agricultural utilization in a manner determined by the secretary.
Is that the same language that 84?
It's not the same exact language, but it's similar.
Does it matter that it's not the same exact language?
Well, there's a little bit higher standard for the LFL, large concentrated animal feed
Yeah.
operation.
But I thought this applied to the LFO before, when you were going.
It
through
did, it does apply to the LFO. I think that's part of the discussion about how it'll apply to the MFO. It's not really the LFO.
Okay.
I also just want to acknowledge the time. I don't want us to rush, but because I want to do this.
Well, you're almost out of the statutory, well, the main statutory changes. All MFOs, LFOs maintain documentation of their nutrient management plan. It has to be available to the secretary. Presumption that a farm is in compliance with. Let me just back up. Right now in law, there's a provision that says if a farm is complying with the required agricultural practices, it is presumed not to be discharged. And this language says that presumption that a farm is in compliance and it's not discharging is not applicable to any CAFO determined to need a CAFO permit by the secretary. And then prima facie evidence of discharge is observed discharge from point source, evidence of a recent prior discharge, such as stained drainage and standing water in a ditch. So the agency doing their inspection, they go out, the secretary sees any of these things, and it's a prima facie evidence of a discharge, which may trigger the requirement to get the CAFO permit. Page 12 on 14, in order to facilitate the adoption of rules that are necessary at the Agency of Natural Resources to implement the program, A&R in coordination with the Agency of Ag is going to engage key stakeholders as a pre-rulemaking process on the proposed CAFO rules. And they're going to look at how they're going to be implemented, how to align that program most effectively with regulatory programs administered by the Agency of Ag, how to create a regulatory clarity for ag producers for the long term. And they will submit all of that to the Union report January 15, 2026. Which will summarize the stakeholder process, summarize public input, assess whether the structure improvements to administering ag water quality requirements is sufficient, recommend any statutory changes. Now you start to get into conforming changes. Section 4 is a conforming change to one of the sections of law related to discharge and permitting. There is in that 1259 an exemption section, and this is saying that the exemption that is currently in law for required agricultural practices is not going to apply in all cases. So it's provided that the introduction of waste are from sources that comply with the Federal Clean Water Act and Federal CAFO regulation, the activities shall not require a BIP's permit. So if you are complying with the Clean Water Act and complying with CAFO rules, and there's a discharge, then if you're a required ag practice, then you are exempt, but otherwise you may need a permit. Page 16, there is language in both Title 10 and Title 6 directing the two agencies to come up with a memorandum of understanding of how they're going to cooperate to enforce agricultural water quality laws. EPA asked that this be removed and that it be more clear that A&R is the primary authority, that they will, instead of having an MOU, that they will enter into a document. You can see that page 16 on 16 through 17. that sets forth the respective roles and responsibilities of A&R in implementing the Clean Water Act on farms, and responsibilities of the Agency of Ag in implementing the state's complementary economic food source program. It replaces the MOU, page 17. So this is really to clarify one of the points that EPA made in their corrective action letter, is that it needs to be clearer that A&R is the sole point source authority for regulating discharges on farms. Any document that the two agencies issue will be reissued every 5 years or reviewed every 5 years. Page 18, line 1, section 5, this is another generally applicable discharge permit section, Title 10, Chapter 47. It's basically referencing when you're required to apply for a CAFO permit, you will have to make an application to the Secretary for a discharge permit and meet all of the other requirements in this chapter section. Again, a reference to the MOU, page 19. Is struck, and not later than December 15th, the Secretary shall amend and issue the medium CAFO general permit and notice of intent. Not later than July 1, 2026, Secretary shall issue a CAFO application and an individual CAFO permit. I'm not sure if this is intended to be done by rule. I guess not.
The individual people
Yeah.
permit?
Yeah.
You just
No,
introduce
but-
yourself for the record.
I'm sorry.
It's
I'm Catherine Guessing. I'm general counsel for the Agency of Natural Resources. It is not intended to be issued by rule, but there is a public process that we will go through in order to issue that permit. Yeah.
Okay.
And
That makes sense because otherwise the timing would be really difficult.
yeah, we actually already have a draft. It's just that we would prefer to have a more robust public process. And we also like to get some boots on the ground on the farms before we sort of.
On page 20 at the top of the page, you'll see that A&R and shall require nutrient management plans for all CAFOs and include the plans and permits for public comment, and may amend permit or revoke the permit in accordance with the Administrative Procedure Act. And once a CAFO is covered under a CAFO permit, the farm shall be covered for a 5-year period. The farm covered by a CAFO permit shall renew unless the farm wants to opt out and can demonstrate it's not discharging. Section 6 is another conforming amendment. This is to stormwater permitting. Currently, stormwater runoff from farms in compliance with the RAPs is exempt from stormwater permit. This is saying that they have to be in compliance with the RAPs and the Federal Clean Water Act is determined by the Secretary. And that's really it.
Thank you. There's a lot in there, yes.
Michael, on top of page 20, set the subsection H. Does that mean that each individual farm CAFO goes through a public comment process? Or is it a general rule for allocating this work?
So there likely is going to be a general permit for these, at least for the medium farms. I would assume for the large ones, they're all being done individually. Because there's only 21 now, 36 when that happened.
I'm pretty steady after the alarm, 35. Sorry, Steve.
So for the individuals, it will be part of their permit application, etc. For the general, you issue your notice of intent to comply. And I think what's probably going to be part of that notice of intent is you're going to have to submit your nutrient management plan as part of your application for the general permit. And that will be public too. How they do that, that's gonna be interesting, because some of these documents are really large. And I'm sure they thought about how some of them have like proprietary statements in them as well. So. Anyway.
Okay, thank you. And to be continued. All right, and we are joined by Secretary of A&R, Julie Moore, welcome. And I was just saying earlier that the order was all, wonky. We're glad to have you.
Thank you. I appreciate you guys taking join or share my screen in the Zoom and then turn on the attention.
You mind if I go to the house floor? That's.
Whatever you got.
Perfect. So, good morning. For the record, I'm Julie Moore. I'm the Secretary of Natural Resources. Appreciate the opportunity to speak with you today about S100, as it contains some pretty essential changes that we feel strongly are needed this session in order to enable the work we need to do to respond to EPA and the petitioners, and implement fulfill some of the commitments we've made through our corrective action plans. So I'm going to talk a little bit about the CAPO petition and EPA's directives, what I see as key elements of ANR's response, a little bit about the nexus with the Senate Ag Committee bill that I understand was going to be passed out this morning, and then our planned steps. And to the extent you've already heard some of this morning, you can just tell me to move it along. But this is the genesis for this work is in a March 2022 petition that was filed by the Conservation Law Foundation and a couple other partners with EPA regarding concerns over the administration of ag water quality programs in the state. EPA spent about 2 years reviewing the concerns raised by the petition, including looking at our files, conducting their own inspections, and in the summer of last year asked the parties, so the petitioners, ANR and EPA, to start to engage in settlement discussions. And really the outcome of those settlement discussions was a shared understanding about what we would propose in a corrective action plan. And then in September, EPA sent a letter that asserted that they had found concerns through their investigations. We were not complying with the Clean Water Act, are not complying with the Clean Water Act, and asked us to propose a series of steps to address those concerns. So I've highlighted several items on this slide and one of the other slides that really show the intersection between what I believe would S100 would enable and the directives we have received from EPA. So the first letter from EPA in September, again, as I heard Michael speak to, talked about that shared delegation of authority and that it was impermissible under the Clean Water Act, and we needed to address that. And that there's concern that we had a version of this conversation before, back in 2008. And we still find ourselves in the same position. And then EPA laid out 7 expectations for the corrective action plan. We were given 90 days to submit our response, and we did send that in within those 90 days and really focused on aligning our regulation of farms with the Clean Water Act. And our corrective action plan outlines a whole series of steps. Defining roles may be most important, as that was a real point of interest in the petition. And then ANR then becomes the lead agency in determining if a farm needs a CAPO permit, meaning we need to be present on inspections and making those decisions as opposed to receiving referrals. Our Our plan includes building on the really comprehensive data management system that the Ag Agency has worked to establish over the last several years, and sort of building our own interface into that system so that we will have a comprehensive set of ag water quality records going forward. As I noted, A&R will join ag on inspections of medium and large farms. We will review nutrient management plans prior to conducting those inspections. There's some rulemaking work we need to do that Michael also spoke to, including an updated Vermont CAFO rule. And then we also need to update our general permit. We are committed to annual reporting and tracking a handful of key performance indicators to demonstrate progress. And then recognizing we don't have the full resources, but we also don't know the full resources at this point, taking a stepwise approach where we are converting an existing position into our CAFO program. The governor's recommended FY26 budget includes 2 new positions to support this work, as well as some contract resources. And then a commitment in December of 26 to report back to EPA with an assessment of what the staff and resource needs will be to run that program in the long term. So EPA responded to our draft, and I would characterize it as you're headed in the right direction and we need more detail. And so this list of 11 things identifies what they saw as areas of focus for us to improve upon in the updated corrective action plan we will submit next week. Again, really focusing on those roles and responsibilities and making sure A&R has the clear authority for regulating CAFOs. And that again ties directly back to S100 and some of these important changes to see made this session. So S100 really focused on the changes to Title 10, so the environmental portion of the statute, as well as the stakeholder process. The Ag Senate or the Senate Ag Committee bill really originally included companion changes to Title 6, the agricultural statute, but now includes the full language of S100 as of yesterday morning. Michael spoke to what I see as probably the most outstanding of the issues that need to be resolved, which is waters of the state versus waters of the United States. As he indicated, CAFO permits are required for farms discharging the waters of the US, whereas our state issued permits prohibit discharges to waters of the state. And so this does create an area of potential tension or at least uncertainty. As you know, the way this framework is laid out on a 5-year basis, farmers may wish to shift between the state regulatory framework and the federal regulatory framework, but having different approaches for which waters are covered by or are subject to that regulatory framework could cause real confusion. And then the other piece I see is potentially more significant, which is the evolving federal definition of waters of the state or waters of the US creates uncertainty. And I don't think it was an exaggeration when Michael indicated that there have been multiple revisions to those definitions over the last 5 years, including ones that have just been proposed within the last couple of weeks. In terms of our plan next steps, we will submit our revised corrective action plan to EPA next week. We are committed to initiating a stakeholder process. I would say we feel strongly that this work should be done with farmers, not to farmers, and trying to create a regulatory construct that meets our obligations under the Clean Water Act, but also can be operationalized by farmers on the ground. We need to immediately, I would say, begin drafting those revised roles and responsibilities. And part of the framework for doing that work would have us publicly notice, draft, and final document that describes those revised roles and responsibilities. And that document will need to be approved by EPA. We also need to start making revisions to be able to issue a CAFO general permit that covers all farm sizes. We do currently have an MFO permit, but it is not fully up to date with the Code of Federal Regulations. So we have work to do there, and then also make it available to others.
And then committed that we would compile an inspection priority farm list based on recent referrals we've received from the ag agency, EPA data and feedback. And other information, and have made a commitment during the coming field season of inspecting at least 3 large farms and 7 medium farms. There's a lot of timing challenges here, and that the resources that are in the governor's recommend obviously don't become available till July 1st. So our ability to have those staff on board will probably be late fall. So it really does limit us to our inspections to sort of what we can accomplish with the 2 staff currently in our CAPO program, the 3rd person that will be transitioned into, or 3rd position that will be transitioned into that program. Recognizing all the other things we need to be doing concurrently. And so I see this as a start. I see the language in S100 as essential groundwork. I don't see this as the sum total of the statutory changes that are likely to be requested, but this is what we need to get going. And a commitment, as Michael indicated, there's a couple of different report back provisions in S100 that will have us back in front of this committee early next session with sort of a progress report as well as reflections on further steps that will be needed.
Thank you for clarifying that last part, because that was something that I had a question about specifically. Because you just had your presentation up here, because so you're getting back to the EPA before March 18th with some more detail. And my understanding is that the requirement there is to have some draft language. I don't know if that's for that letter or that correspondence. No, okay. So I guess because this is kind of this is an iterative process with the EPA. Correct. And so anyway, the concern I had was, I have a couple of concerns, but one is, if we pass something and it continues to iterate, just thinking that, there may be further changes that need to, so you're anticipating that may be true anyway.
Correct.
Okay, and the other thing that was on my radar is, I just want to be really clear about the things that you feel need to, like the sense of urgency, like what is it that we need to do now? And what I'm hearing is that it is that you want to get rolling. Well, so it sounds like you want to conduct some inspections to get started. Awesome. I think you need permission to go on to these farms.
Yes, I mean, I think explicit as envisioned in this one.
And so that does feel urgent. And beyond that, knowing that it's going to be an iterative process anyway, what is the urgency beyond like getting permission to go on to farms?
So I'll go start and then phone a friend.
Yeah.
Have Catherine help here. But a part of it is, as we are going about updating our rules or creating a CAPO rule, the CAPO general permit, we need to make sure we're trued up with the Code of Federal Regulations. And some of these definitional changes are getting at those needs.
Mm-hmm.
I don't know, Catherine, if there are other specific pieces that you would highlight.
Yeah, Catherine Guessing, General Counsel. I think it's really helpful in terms of the work that we have to do to have those federal definitions in the statute. It gives us clear authority to require permits for large farms that are discharging. It gives us clear authority to exercise, our directives to make directives to farms it allows us to review and approve nutrient management plans. Some of the detail that I think Scott Sanders spoke about is going to have to come through the rulemaking process, but having a basis in the statutes that kind of sets the stage for what our jurisdiction is, at least initially, will be very helpful in that process. It will also be helpful in just emphasizing to farmers that we do actually have the authority to require a permit under certain circumstances. We do have the authority to come and inspect. We do have the authority to look at their nutrient management plans. And we also have the authority to require them to make those documents available to the public, which is something that the Clean Water Act specifically requires.
That's helpful, thank you. Any other questions? Please,
I have a question. So the definition of the waters, whether they're the waters of the state or the waters of the US, right now S100 is a little inconsistent. I think what I heard from you is that, well, which definition just to be clear, which definition do you think we should be using?
I think waters of the state has the most
Okay,
consistency.
that's what I thought. Okay, that's what I thought I heard, and that's what it seems to me makes most sense. Does the version that the Ag Committee did they make it consistent and use that definition?
We had that same conversation yesterday and it was unclear if they plan to make changes.
Okay, well, that might be something this committee could amend, just do an amendment, because I think it makes sense to, especially given the tumult at the federal, I mean, they may just not define water anymore, who knows? So,
well, and I have a further question about that. In the bill, I think there was a definition of waters. When you say waters in the state, is that different than waters? Does that make sense?
It should.
So when you say water in the state, you mean waters as it's defined
on page 2, paragraph 13.
So if I may, yeah, I've been guessing again. I think our original strong intent was to align our CAFO program with the federal program, and that we acknowledge that the definition of US waters is narrower. Given kind of all the federal uncertainty around these issues and the fact that we got a notice yesterday saying that they were going to take up rulemaking on federal waters again, and the fact that AG's programs also focused on state waters. And we really feel that US waters are included in state waters. We felt that it would be good to have a consistent definition. So I think we just need to have a conversation about that. You know, and let the stakeholders, including AG and others, kind of weigh in. I think the intent with that with the waters was just, I'm not sure. I'm not sure at this point whether waters of the US or waters of the state. I'd have to look at that again in more detail, but throughout the CAFO regs, the original intent was US waters.
Well, thank you, and I am appreciating Senator Hardy's suggestion around this might be something that we could offer an amendment around. Let's have some more conversation about that or how that ought to go. So to be continued on that. Any further questions for Secretary Ingber? Yes,
sorry, I was thinking of the things that Michael brought up and a possible amendment from this committee is the point of and this might be a question for you more than secretary, but this definition of precipitation related to discharge of manure that's in the large CAFO, but not the medium CAFO, and his question was, should it be added? He thinks you might have the authority anyway, but clarity's sake, should it be the same?
I think we may need to get back to the committee on that. It may make sense to take it out of the large farm definition and just leave it in that section. Because
general part.
My sense, when I believe that it is applicable to medium farm operations, but I'm just not certain. I tried to look it up while I was sitting.
Well, we should just continue
There's
to
another
talk about that.
subset of regs that I don't have access to.
Okay.
So.
Okay, so just to put a pin in that and flag it for
Thank you.
just make sure it's consistent.
And we can get back to that.
And then the final one is the continuous discharge definition of whether that's necessary.
So, though the continuous and daily discharges were something that, EPA flagged as missing from our our NICS regulations in general. They may not, they may not come up in the CAFO NICS context, but they definitely come up in other scenarios.
Okay,
So.
okay.
Great. All right, thank you so much.
Thank you.
And I would like to take a little break before we jump into the next topic. So let's go with like a 4-minute break. And we gotta go.
There you go.
We gotta, oh, where's Senator Beck? He was just here. He's
Oh, you talking to you?
He was, and then he didn't make it in. I think we should get rolling now. Okay,
Right.
welcome. Hang on, are we live?
Yep.
Oh, we are. Okay, amazing. Welcome.
For the record, Peter Walk, Union Director of Missions Vermont, here wearing my DEIC hat. Thank you for the opportunity to provide one final moment of testimony. S65 will help more Vermonters, particularly low and moderate income Vermonters, save money, tighten up their homes, and transition to cleaner, more efficient technology. It does this without raising costs for Vermonters. There will always be different policy perspective and interests, but you have allowed each perspective the opportunity to be heard and to inform the outcome. You have listened and incorporated specific witness feedback. The committee discussion has been robust, and S65 is better for it. When you created Efficiency Vermont in the late 1990s, it was an innovative action to save Vermonters money and reduce their overall energy burden. For the past 17 of those years, you have directed energy regulators and the energy efficiency utilities to prioritize greenhouse gases alongside household and business energy savings. You have made your greenhouse gas emissions priorities clear, but the regulatory process has not produced the outcomes you're directing. The modest tweak to our mission you are voting on today reaffirms your founding direction and reflects the changing energy policy landscape. I thank you for the opportunity to speak today and to congratulate you on crafting a bill that offers both greater affordability and greater climate action. Thank you. I wish you luck with your book.
Thank you. Any further questions for, yes, go ahead.
Just reiterate for us. What impact is this going to have on the ground? How's this going to play on the ground? It's different than it's out of the ground now. Just to touch on that.
Of course, every 3 years we develop a plan that produces that mix of measures that you saw in that spaghetti chart of activities. We will look at all of the priorities that you've set and propose a plan that provides greater weighting to some of the greenhouse gas work than is currently weighted on. But it will still drive the electric efficiency savings and dollar savings for Vermonters that you already asked us to do. So it'll be a modest set of shifts within that framework.
And what will that mean for the people used to cut it? How will that play out differently?
We will likely provide additional support or try to seek more equipment transformations and more weatherization projects. I think the most important piece is the equity section that you've added that really focuses us on helping Vermonters, low and moderate income Vermonters, make the transition alongside those people who can already afford to do it now.
Great, thank you. Okay, yes, welcome to our legislative council. Hello.
Ellen Tchaikovsky, Office of Legislative Counsel. I'm here today on S65 draft 5.2. The changes from yesterday's draft are highlighted in yellow. And so when I left yesterday, you had proposed a couple of specific language changes, and then there are a couple of other additional language changes. But I think they are all in the last sections of the bill, the clean heat / fuel cellular registry. Yes, so the first change is on page 19. In section 3, the heating fuel seller registry. So each entity that sells heating fuel for bulk delivery in Vermont shall register by June 30th each year with the commission. I also strike the word annually from this sentence because it already says each year there. The commission shall maintain and update annually the list of registered entities on its website. And then there's also this new language here. The data collected in this registry may be used for multiple purposes, including for calculations related to greenhouse gas emissions in the state, verification of fuel sales data collected by the Department of Taxes, regional and municipal energy planning, and professional development and notification purposes.
This was
to try to get at the conversation yesterday about a purpose for this.
Yes. Senator Williams, this is something that you had some interest in, so,
Yep.
Does that help for you?
Page 19.
No,
Okay, so then there is another change on page 20. So this is the data. And I'm not entirely sure if this captured what you were asking for, but so the commission shall require registration information to include legal name, doing business as name, municipality, state, types of heating fuel sold, and the monthly retail sale of gallons of heating, oil, propane, kerosene, and other dyed diesel delivered in the state in the calendar year immediately preceding the year, which the entity is registering with the commission, separated by type.
This is the same language that's in 33 VSA, section 2503, correct?
Yes. And so I wasn't sure if it fit here. Is this where you thought it would fit?
Well, this is generally where we were talking about it, and
Right, so this is the type of information that they would be submitting.
yeah, so gallons and all of those things. Think that works. And then we got rid of the or final sale or consumption.
Right.
State, yes.
Yeah. Okay. Cool, carry on.
And then there's a couple of small tweaks on page 21 in the fuel tax report from the Commissioner of Taxes. So the report shall include the aggregated data broken out by type of the volumes and types of heating fuel sold annually in Vermont and the number of entities that pay. So it's on page 21.
Great. Any questions about that? Okay, there are a few very targeted suggestions that we have to make further. And so we did get some, we got an email from Mr. Dakota yesterday about some changes that he would like to see. And I think there's a way that we can incorporate all of them with an asterisk. So let's start with the suggestion about the report at the end.
Section 6.
Section 6, yep, so. So suggestion was instead of the Public Utility Commission, that'd be the Public Service Department. I'm okay with that, if you all are okay with that. So there's that, and then wanted to include in consultation with the Vermont Fuel Dealers Association, that's fine, at least with me anyway, and other agencies of government. The thought was to include in the list of things they're going to report on, including heating fuel delivery providers, which gets at the name, but the thing is, one of the things that he had wanted to do away with was the heating fuel sellers registry in the first place.
So I think that goes back to.
Yeah, that goes back to section 3.
Right, yeah.
So, one possible solution here is that we say, if we get information on how to best do this, then we can, if we just start on page 19, line 13. Yeah, page 19, line 13, start with beginning in 2027. That way, we will still be collecting this information, but we might get a report on how best to do it. It's still there, and we have time to revisit it, if possible. I realize this is a last minute change. And
Is it maybe,
Yeah,
sorry,
it's okay, go ahead.
for that, instead of starting that sentence at the beginning in 2027, just having a delayed effective date for this paragraph.
That would be fine, if,
For the heating fuel cell registry,
Yeah.
because that's what you're talking about, right?
exactly.
Is delaying that till 2027, so just saying. Having that start on January 1, 2027. So then they would report in. June 30th, 27.
Yeah, I think it needs to be clear, after. Just need to be clear that the report is driving the registry, not that the registry is going to occur. Because if we put a section here that says it starts on whatever, January 1, 2027, then that's when it starts. I wonder if it wouldn't make more sense to take some of these ideas in section 3 and build out the report. And, this is what the report is. Will, make recommendations on, with a recommendation for effective date.
Well, I think that, having the registry happen starting in 27, the report is due in 26.
Right.
Yeah, early, so that gives us a whole session to make tweaks to the registry. But having it in there allows the department or the commission or whoever we're having do with the registry. To start getting it going and getting, the stuff in place, and it allows the fuel dealers to have notice that they're gonna have to provide that data.
Yeah, I just think the more prescriptive section 3 is, the more problematic. Because it's the report that's gonna, inform.
Right, well, but we would theoretically have time. There are a couple other changes that Mr. Cotta suggested by changing it from the commission to the public service department. And I'm open to those changes as well.
So it would be each month, I'm just looking at line 13, the section for the.
Yeah.
So each year with the public service
Right,
department,
instead of the commission.
the public shall maintain and update.
And I think there's some other references as well in terms of like line 20. So they're not in the room. I was thinking at it here.
I just want to be really, and I appreciate that use PSD instead of commission. But I just want to be really clear that whatever word happens in 2027, that's informed by the report, and and it's not, if we get too prescriptive here, then this becomes law.
Yeah. What if we said, either making this, having that delayed start time, either by a different effective date or by saying beginning of 2027, open to either. We say, as informed by the report, yada, 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 like keep the rest of it, but as informed by.
Yeah, I think that's the big, so if we get to
Done.
2027 and we don't take any action,
Then it happens.
then what happens? And if that's what I want to, because in some ways we are passing that,
Right.
Yeah,
Yeah.
but I think that, we've had a long conversation around this table about the value of having the data, the value of.
Yeah.
And I think that by making it contingent on other things, we're just gonna have to have that conversation again next year. So I think going into next session by saying, we want the data, we need to have the registry to get the data. And we're gonna have this report that might help us make that a clearer way to collect the data. Then we don't have to have the same conversation. And this is just data collection. It's nothing like, there's no requirements for anything to be done. And the purpose that was added was at the request of, Senator Williams, just to make it clear, why are we doing this? Why do we want the data?
Yeah.
These are some of the things we all talked about as to why the data is important.
Okay, I just think, I think it would be helpful if it, there's some language in there, you know, as informed by the reports and things like that.
I think if we keep all of this language and we just add, including it like as informed by this report, I think that would work for me. Okay.
Changing the commission to the department.
And changing the commission to the department, and I believe that is it. Does anybody have anything else that you want to flag or raise? So we're trying to meet. Ellen is like, what are we talking about?
There's also, it's all in sub C's commission's use as well.
Yeah.
We'll have to change all of it.
Yep.
And then,
Yes, C will have to be reworked.
do you understand under section 6 what you're being asked to be doing as well? I didn't quite understand it, so.
I mean, I didn't hear much of a change in 6.
Sorry, so I did forward on to you the email from Mr. Comer, but
Just now?
pretty recently.
It just says add, I wrote down add heating fuel delivery providers, I don't.
Yeah, let me look at that again. So changes again, PUC to DPS. And in consultation with the Vermont Fuel Dealers Association. And any other government agencies.
And any other,
Well,
and any other government agencies?
well, I guess we don't have to say that, because they'll do that anyway,
Okay.
right? But the key is that it also includes, just want to find the right spot here. Okay, on line 18, where it says the best way to collect data on adding a phrase here on heating fuel delivery providers and deliveries. And heating fuel delivery on a town basis, et cetera.
I'll just point out that you haven't used the word provider before, you've been using the fuel sellers.
Oh, okay, well, let's use
But
that.
I don't know if there's a distinction between that.
It's a heating fuel delivery, it's fine.
Well, I think we're looking for the people, so. The way that but I hear you though, that is not a phrase that we've used. So how about entities that sell heating fuel for bulk delivery, because that is the phrase that we use in section 3.
Well, we call it the heating fuel seller registry.
Yeah, oh, yes,
Yeah.
that was true. We could call them fuel sellers. I think either of those. I'm out of either of those works.
What? So it's going to say the best way to collect data on
Yeah. On,
heating fuel sellers.
yeah, who the heating fuel sellers are.
Heating fuel sellers and heating fuel deliveries on a town by town basis.
Does that help them?
Yes.
Okay, and then
So,
as informed by the plan should be is screen.
where?
Yes, so
On line 13 on page 19.
yep, so starting with as informed by the report.
Steve, sorry. Okay, I'm on page 19. Where? Or what line am I on?
I think we're just gonna start right on line 13. Okay, actually, let's go with line 14, in that second sentence. As informed by the report. From, I don't know how you reference the report that's coming out in section 6. But as informed by that report, the commission shall maintain and update annually the list of registered entities.
I think the one problem is that report is in session law, it's not in the statute, so it will go away. Yeah, that makes it hard, this is statutory, that is session laws.
Could we say as generated by this? Okay. And let's have an effective date for section 3 and section 4. And section 4, actually is as January 1st, 2027.
Okay, so I just want to point out that that is gonna make this stop the current data collection, the PUC is already doing, have a 2-year gap. And then restart.
Yes.
data collection.
I think that's okay.
It's gonna stop data collection, see,
Right, correct.
and restarts it.
With the public service. department.
Yes.
Yes.
Okay. Whew. All right, team, are we ready to take a vote? Sorry, was there any, oh, sorry.
We're gonna vote before we have a draft.
I
Oh,
think we should see that.
We know, we should.
that's fine. We do have the floor. Can we meet? It's gotta be today.
4 o'clock.
That was.
Can we meet right after the floor?
I can come down after the 4.
Okay, thank you. My apologies that this is so last minute. Okay, thank you. I will see you after the floor. Onward, maybe.
I'm booked all afternoon, so I may or may not be here.
Okay, that's all right. I think if we have a job to look at, I think we'll be. Oh, yeah. Fine, yeah. Yeah. Okay. Scott, thank you. Does this sound okay? Well, we can talk about
Go
it.
get us to Boston.
Yeah.
Everybody's not okay, that's right, 31 of you.
What everybody's on. Oh dear.